In Chapter 3, we will be going over legal liability and insurance. This is one of our chapters that feels a little boring at the beginning, like it could be boring, but it is very important to understand these areas of sports medicine. And also, on top of that, the insurance aspect of things is really helpful for all individuals to start to understand a little bit more about the medical insurance policies and other kinds of policies that you could have as an individual. As far as legal concerns go, we have a couple of definitions that we want to be aware of when it comes to our legal responsibility as a clinician. First, our most important thing is liability. So this means being legally responsible for the harm one causes another person. So just because we treated a person and we didn't get a good outcome, that does not mean that we are legally responsible for that outcome. If we did what we knew to be best and the person still died, say for instance, that doesn't mean we're legally responsible for that person. Next, we'll talk about standard of reasonable care. So when it comes to legal liability, the courts will look at, did you as a clinician do what a reasonable and prudent person in your position would do? So our standard is not perfection. Our standard is being reasonable and prudent. So say for instance, if I was treating someone and they had gotten sick and I was in a position to prescribe them antibiotics and I gave them a normal antibiotic that we would usually give somebody in that situation, but it didn't work. And then I found out later that another antibiotic probably would have worked better in that situation. I still performed a standard of reasonable care. I did something that somebody reasonable and prudent would do. I prescribed a medication that was the normal type of medication. It just wasn't right in that situation. So also under duty of care, we want to talk about having responsibility to give care. So if, as an athletic trainer, I'm driving home from work in my car and I come across a car accident and I just don't have time to stop, I don't have to stop. I won't get in trouble for that. I don't have a duty to respond in that situation, although it would be nice for me to do that. If an off-duty police officer in his police vehicle drove by a car accident and didn't stop to give care, they could be sued for failure to provide duty of care. I guess one of the best ways I have to explain this also is, one day I accidentally wore a red polo shirt to Target after I had covered an event where I was required to wear a red polo shirt. And as much as it irritated the heck out of me that people kept asking me for help at Target, I was on accident representing myself as an employee of Target. So I guess I kind of had a duty of care in that situation. So another thing as far as standard of reasonable care is we want to discuss is torts. So a tort is a legal wrong. We have a couple different legal wrongs that we can perform when it comes to not acting reasonably or prudently. So the first is nonfeasance. So that's a failure to perform a duty. So if I was standing on the sidelines of a rugby game in my athletic training uniform with my fanny pack and presenting myself as if I was available to work, and somebody got hurt right in front of me and they needed CPR performed, and I said, nope, I'm not going to do it. I don't like that guy. He was rude to me earlier. Then that's nonfeasance. It's a failure to perform a duty. Malfeasance would be doing a task that I was not trained for. So the rugby player needs CPR, and I decide I'm going to give him a tracheotomy. I don't know how to do that. I'm not qualified to do that. So if I did do it, that would be malfeasance. Misfeasance would be if I did CPR incorrectly. So say for instance, if I put my hand over his belly button to perform chest compressions instead of in the middle of his chest, that would be doing the task incorrectly. So nonfeasance means I didn't do something I was supposed to do. Malfeasance means I did something that I didn't know how to do. And misfeasance means I did something wrong that I should know how to do. So some more concepts under standard of reasonable care include negligence. So negligence would be an unreasonable action. So again, somebody gets hurt right in front of you and you're just like, I don't want to treat you. I don't like you. That would be unreasonable. Another thing that that should be taken into consideration too with standard of reasonable care is the Good Samaritan law. If we are acting within the boundaries of our training, which is also known as scope of practice, we are not legally liable for issues that arise while properly administering first aid to someone. So if we follow our training, if we do what our training has outlined, we are not legally liable for issues that arise. So if you were first aid trained only and you follow first aid training and do what you're supposed to do and something bad happens, you're not legally liable. You did what you knew to do. If you were CPR trained but not lifeguard trained and somebody was drowning in a pool in front of you and they had hit their head on the bottom of the pool and probably broken their neck, and you dragged them out of the pool and gave them CPR but weren't careful with their neck, you wouldn't know how to do that. You wouldn't know how to be careful with their neck when you're taking them out of the pool. You're trying to save their life. So you would not be legally liable for any neck injuries or any issues that came up with a neck injury later on. Another issue would be assumption of risk. And this is, most of you have probably signed a waiver at some point before an activity that said that you understand that there are risks involved in activities. This is common in any kind of sports class or if you join a gym or anything like that. And we call it a waiver, a risk waiver. The thing is that on the administrative side of things, you need to have proof that somebody has waived their assumption or that they've understood their assumption of risk and that they've waived that. So we need to have it in writing, so we need to have a paper that the person has signed. As far as with our legal responsibilities as sports professionals, there are things that can be done to decrease our chance of litigation in sports and fitness. So basically, this is a list of things that we can do to try to avoid getting sued for any of the legal issues that could come up from working as a sports professional. Number one, we can warn the athlete or participant of potential dangers inherent to activity. So we do that via the assumption of risk waiver and we have them sign it so we have proof of that. We can supervise the participants attentively. So we're going to make sure that people aren't doing stuff that could injure them while they're at the fitness center, say for instance. We're going to make sure that athletes on the rugby field are trained as well as we can train them in their position, and we'll make sure that they're not doing something like tackling improperly that could hurt themselves. We want to properly prepare and condition the athlete, same idea, making sure that they're strong enough and healthy enough to be doing what they're doing. This is really important. We want to establish good relationships with participants and parents. People don't sue people that they like, they just don't. If you've worked hard to establish a good relationship with participants and parents, you're very unlikely to get sued. Some people have issues as far as psychological issues, so they might sue somebody that they like anyways, or if they had just no money and they needed to pay for a surgery, they may sue someone because they had to, because financially they didn't have any other option. But as a general rule, people just don't sue people that they like. We want to establish and follow specific first aid policies and procedures. This is part of why having an emergency action plan is so important. We want to make sure that participants and athletes are following advice from their doctors and athletic trainers, because if not, then you're legally wrong. You're legally wrong if you're allowing somebody to participate when they're not cleared to do so. We also want to use common sense in making health and safety decisions. Unfortunately, common sense isn't as common as we would like to think it is. Changing directions a bit, we're going to talk about insurance. So first we'll talk about types of insurance, and then we'll touch on insurance billing a bit. Some important terms to remember when it comes to insurance, when we're talking about those different types, will be deductible, copay, and premium. So those of you that are on your own insurance have heard these terms before. Whether or not you know what they mean is another thing. And those of you who are still on your parents' insurance will need to know these at some point. So I'm glad we're going over them. So our deductible is what we must pay prior to the maximum payment by an insurance company. So if your deductible is $3,000 for your insurance, that means that you will need to pay $3,000 out of pocket before the insurance company will pay for everything when it comes to your health care. That doesn't mean that you have to pay for everything out of pocket before that. So it doesn't mean you have to pay for every doctor's visit, every surgery, every, whatever to meet that maximum. It just means that the money that comes from you will have to add up to $3,000. So the insurance company might still pay for part of your doctor's visit or part of your surgery, but whatever you paid as a part of that would eventually have to add up to $3,000 before the insurance company would pay for the rest, or of all of your health care. Our copay is due at the time of service. So this is money that we owe when we're at the doctor's office. So if our copay is $40, that means when we go to the doctor's office, we're going to pay $40. And usually those copays count towards our deductible. So if you go to the doctor a lot, you're basically adding to that bank of money to get closer to your $3,000 of deductible. Our premium is what we pay each month to carry the insurance. So our premium is our membership fee. That's our membership fee to be a member of our insurance company, basically. So premium is the membership fee. Copay is what we pay when we go to the doctor's office, say for instance. And deductible is the amount that's set by the insurance company that we will have to reach of our own money going in prior to a maximum payment by the insurance company. So they will pay 100% of your medical bills after your deductible is met for that year. So we are going to talk about a few different types of health insurance. It is important to note that our deductible, copays, and premiums and injury or illness coverage vary for health insurance based on the contract with the insurance company. So for those of you who are on Covered California, the coverage may not be as good as somebody who has workplace insurance. The numbers that I'm giving you guys for the different kinds of insurance on these slides is what I used to pay back in 2011 for my insurance when I worked at UCSD. I'll mention the differences between that and what I paid on our Covered California plan for the last couple of years. So our first type of health insurance is an HMO, or Health Maintenance Organization. The nice thing about HMOs is that these are usually the least expensive for the insured. So as an individual, I am not going to pay as much for my premium or my membership fee for an HMO. There are more restrictions with an HMO than with other types of healthcare plans. So with an HMO, you must see your primary care physician before a specialist. Probably the only exception to that would be something like if you wanted to go to your women's health doctor, you don't necessarily need a referral from the primary care physician. But if you wanted to go see an orthopedic surgeon, say for instance, you would need a referral. HMOs can have good benefits, so that means that they will often pay for a lot of things, and they will pay more possibly than the other types of insurance for similar services, but we may not have as many choice in providers such as doctors, physical therapists, and pharmacies. An example would be when I was on Kaiser in 2011. There were a lot of services that were included at Kaiser. I actually had a really good benefit for vision through Kaiser. I had good benefits for a lot of things, and I think it was very low cost for me. As a UCSD employee, my premium or my membership fee was $6 a month, and my copay was $15 for most services. So my copay for going to the doctor was $15. That's pretty incredible, especially after I tell you what I pay now. Even after I had my son, when we were still on Kaiser, our premium was $24 a month, and I think at that point my copay had gone up to $20 for a doctor's appointment. So $24 a month for 3 people to be on my Kaiser insurance when I was at UCSD. Fast forward to about a year ago, on a different HMO plan through Sharp, our premium for 3 people through Covered California, $1,200 a month. That's our premium, up from $24 a month at UCSD for 3 people. And my copay, instead of being $20, was now closer to $50. So having good insurance through work can save you a ton of money. Do not discount, when you're looking for a job, what the insurance package is like. You want to know that before you go into getting your first full-time job. Look and actually sit down and try to crunch the numbers and figure out how much money they're going to be saving you. At really large companies like UCSD, it is absolutely worth a ton of money. The main thing with the HMOs is that you have fewer choices in providers, medications, and treatments. And there are some things about Kaiser, especially the physical therapy department and some other policies that I don't particularly care for myself. But if you don't want to be spending a ton of money, it can be a good option. Now, Kaiser at other facilities or in other jobs may not be as inexpensive as this was for me, but at the time it was a very good option. Another type of health insurance is known as a PPO, or a Preferred Provider Organization. PPOs may have a large deductible. Up to $3,000 a person was common in 2011. You can have more choices, and you can, but you pay less for network providers. But if somebody is not a network provider, the insurance would still cover going to see that person, but they won't cover as much. If you wanted to see an out-of-network provider and you had an HMO, you would be paying full price, whatever that person charges, whatever the individual charges for people who don't have insurance. So you do have more choices as far as the PPOs go. An example as far as a Blue Cross PPO, when I was at UCSD, we did have some flexibility there. I did not need to see a primary care physician first if I wanted to have a PPO. It was higher cost at that point. At that point, the UCSD employee premium for me by myself was $74.29 a month. So that's a difference. That's basically 10 times more, a little bit more than that, than what I had been paying with Kaiser. My deductible would have been $250, so that would have been whatever I paid out of pocket would have had to be at least $250, which is pretty much nothing at this point. And the copay would be $20 for in-network services, which comes out to be at least $50 a visit. So while my copays for Kaiser were $15 a visit in that same time frame, my copay for Blue Cross would have been $50 a visit. So 3 times more for the copay, 10 times more for the premium, and the Kaiser insurance did not have a deductible, so I didn't have a minimum to meet as far as paying out of pocket before they covered everything. So again, now looking at what I'm paying for an HMO that has a deductible, this is not very much money. But compared to what we were spending for Kaiser, it was a lot of money. The main benefits for the PPO is that you have more choices in providers, medications, and treatments. So one is not better than the other. An HMO is not better than a PPO. It really just depends on what you think is more important as an individual. Is saving money more important as an individual, or is having choice more important as an individual? It just depends on what's important to you. Your book covers another type of insurance as well called point of service. Now, there are lots of other types of insurance now that don't fall under specifically the HMO or PPO category. They would probably be more of a hybrid like this point of service is. It might be known as an EPO, or I don't know. There are many different kinds now. There are others, but a point of service or POS has similar rules as an HMO with some attributes of a PPO. So basically, most likely that's meaning that with the POS, you'd still need to get a referral from your primary care provider to see a specialist, but you can see out-of-network providers, which you could not with an HMO without paying full price. You can always pay full price and see somebody. Our last type of insurance is actually a lack of insurance. So we call that fee for service. So fee for service means that you do not have insurance, you pay for everything out of pocket. So if you don't have insurance, you pay for the service you receive. That's why we call it fee for service, because you pay money for the service that you're getting. The thing that kind of stinks about the American healthcare system is that insurance companies pay only a small fraction of what the doctor's office actually charges them. So when you end up having to pay fee for service, things are super expensive if you pay that normal fee that they would charge the healthcare or the health insurance company. You know, one of the companies that we had a contract with at one of the PT clinics I worked at in Michigan, the healthcare company or the health insurance company would only pay 20% of what we billed. So if we billed them $100 for a PT visit, they'd pay 20. So that means that the provider then jacks up their price to within the standards set by Medicare. They'll jack up their price to then try to get some semblance of what would be a fair price, essentially. But as a person who's paying out of pocket, you end up paying the jacked up price. But if you know that you have to have a doctor's appointment or have a surgery or a service, you can try to bargain with your doctor over the cost of a planned service because they know that they're overcharging for things because they have to overcharge the insurance companies. So there are some doctors who either won't deal with insurance companies at all and they just choose to treat people who can afford to pay them out of pocket, or you may be able to try to bargain with your doctor. My dad has successfully done that when he went on COBRA insurance that ended up being very expensive after he retired and he needed a medical procedure that was not necessarily planned ahead, but he was able to talk to his doctor about it and his doctor was willing to discount the cost of his surgery. So most people don't bother to ask, but it is possible to try to get a reduction in price. So stepping away from medical insurance, some important types of insurance that a school or a company might have to try to protect themselves from legal liability would be an accident insurance or catastrophic insurance. At a school or a company, accident insurance will cover a campus or supervised event. This is going to be purchased by the school or company, and it helps the student financially with, or a participant financially with a covered injury, and it decreases the school's liability. The lower the deductible, the higher the premium usually. And deductibles vary based on the contract with the company, with the insurance company. So when I was responsible when I was at UCSD for purchasing an accident insurance to help cover sports clubs accidents because our student health insurance decided that they weren't going to cover that anymore for a couple of years. So we had purchased an accident insurance policy. I believe it was for, I believe we paid $5,000 for as a department for that coverage. And we could have gotten a cheaper plan, but I wanted to do, because I felt it strongly that our students should not have to pay for an injury that occurred while they were playing sports for us. So I wanted to make sure that we had a $0 deductible. So we paid $5,000 a year for that, and we had a higher premium. If we had wanted to give the student athlete a $500 deductible, then I believe our premium or our membership fee for that would have been $25 or $100, so $2,500. Um, for that accident insurance, we actually had the limit go up to $15,000 because our catastrophic insurance had a very high deductible that had to be met. So the catastrophic insurance would pick up once somebody's expenses hit $15,000, but not before. So we had the accident insurance cover that gap. So the accident insurance would cover $0 to $1,500, and then the catastrophic insurance would pick up after that. Catastrophic insurance was basically just for major injuries. So if somebody needed surgery or hospitalization, they would have been covered by that catastrophic insurance. For the catastrophic insurance, it could have a time limit or a lifetime benefit. So it may say, for healthcare needs within the next 5 years after the injury, they'll be covered. Or if there was a spinal cord injury, there would be a lifetime benefit, say for instance. But that's all dependent on how the contract with how the insurance company writes the contract for the company that's purchasing it. Insurance billing. Oh my. So insurance billing is an interesting concept. As athletic trainers, we technically don't have a responsibility to manage billing. So say for instance, in a physical therapy clinic or a doctor's office, it could be a physical therapist's job to help manage insurance billing. But as athletic trainers, mostly our professional responsibility is to help coordinate things to the extent that we can. But the financial responsibility is the students as far as insurance billing. So a lot of times as athletic trainers, we'll have a student athlete bring us their bills and their explanation of benefits to try to help them figure out what they owe to make sure that everything lines up. Also, if if the accident or the injury was covered by those other insurances we just spoke about, the accident or catastrophic insurance, we would need to make sure that we were filing claims for that and trying to coordinate between their primary health insurance and those other insurance companies as well. So basically that's talking about that an athlete could have 2 to 4 different insurances covering their accident. So if a student athlete was on their parents' insurance, health insurance, that would be a primary coverage. The accident insurance could be a secondary coverage. At UCSD, we also had travel insurance. So if an athlete was injured on the road, they could be covered by travel insurance. And then also, if it was a bad enough injury to need surgery, they could be covered by catastrophic insurance. So I did have one athlete who, over the course of 2 years, was injured a few times. The first 2 times, she was on the student health insurance that was not covering athletic injuries at the time. So we knew they were going to deny things. So we just put her claim straight into the accident insurance and the travel insurance because she was hurt off campus. And then the catastrophic insurance. So those 3 covered her first ACL surgery. Then the second time she was injured, she was on her parents' insurance. And so that health insurance actually did cover part of her care. And then we no longer had the accident insurance policy, But then at that point we had the catastrophic insurance policy. So, and she'd also gotten hurt on the road that time too, so we also put things through the travel insurance. So it was kind of a lot of business, and most of the time you're not going to be dealing with that many different types of insurance, thankfully, when you're working with athletes, but it could happen. We do need to encourage students to pay their bills in a timely fashion, or that student could be considered in default and they could get sent to collections. And we don't have a responsibility for that. The student athlete is responsible for their own bills. Our responsibility is just to try to help them coordinate. They have to ask for help though and make sure that they're paying bills that they owe. As far as personal liability insurance, I believe this is very important. Oftentimes, personal liability insurance is provided by large schools and businesses for their employees. I would say I've only been involved in one lawsuit, and I was not the one being sued. But from my viewpoint, our lawyer that was hired by the business we were working for had the business's interest in mind, not mine, not my coworker who was being sued. So I think it's best to supplement with your own insurance. For athletic trainers, the certified athletic trainers, it costs about $250 a year for $1 million coverage. This is a requirement for the athletic training professional program for athletic training students. But the student rate is very cheap. It's about $75 a year. Again, this is just to protect you in case somebody says that you did something wrong. Even if you did do something wrong, it's going to help pay for your lawyer. It's going to help pay for any judgment that you had. Fitness professionals can benefit from this too. So I have two different links here. I'll put two different links up on the web links. There is an ACE recommended insurance and an NASM recommended insurance for fitness professionals that you can follow through the links I'll post on the web links.